Thank you for staying with us. The Attorney General of the Federation, Lateef Fagbemi, SAN, has asked the police to transfer the case file of protesters arraigned on the 1st of November at the Federal High Court in Abuja before Justice Obiora, who were alleged to be minors. The AGF, in a press statement, says there are some issues his office will need to look into to make an informed decision. Celestina Area reports.
On 1st November 2024, the Nigerian police arraigned 119 protesters before the Federal High Court in Abuja. Out of the 119, 76 were believed to be minors, while 43 were above 18 years. They were arrested on 3rd August in various parts of the country: Abuja, Kano, Kaduna, Zaria, Katsina, Gombe, and Jos. They were arraigned before Justice Obiora on a 10-count charge of terrorism, attempts to overthrow the government, and mutiny over their participation in the nationwide protest which took place on 1st to 10th August 2024. They looked pale, starved, and exhausted. 4 out of the alleged minors slumped in court when docked to take their plea. These startled Justice Ekwatu and forced him to rise abruptly. Lawyers for the defendants scrambled to obtain snacks for the suspects to boost their energy levels.
12, 13, 14 years old.
Shortly after, the court reconvened. Justice Ekwatu struck out the names of the 4 defendants who slumped due to ill health, after which the remaining defendants pleaded not guilty to the charges when it was read to them. They were subsequently granted bail in the sum of 10 million naira each, with 2 sureties in like sum. The judge held that one of the sureties must be a level 15 civil servant and the other a parent of the suspect. The sureties must make available to the court a means of identification with a verified address, letter of last promotion, and letter of appointment. The defendants were remanded at the Postal Center, Kuje, pending the perfection of their bail conditions.
We will strive and do our best to perfect these conditions. But if we cannot meet those conditions, we will come back to the courts and seek for a variation.
Counsel for the prosecution disagrees with counsel to the defendants that they are minors.
These boys that we brought to the court today, all of them are adults. Most of them are married men. None of them is a minor. Some of them are university graduates. The small kids you are seeing here, they came with some of their parents to come and greet their loved ones.
The Attorney General of the Federation, Lateef Fagbemi, has asked that the case file be sent to his office. The AGF, in a press statement, says that there are some issues his office will need to look into regarding the matter to enable him make an informed decision. He says the case was adjourned to January 2025 and it is not within his powers to vary the order of court remanding the defendants in detention center and the adjournment. However, he has instructed the Director of Public Prosecution of the Federation to immediately begin a process for consideration of the court to bring the adjournment to an earlier date. Section 174, subsection B and C of the Constitution empowers the Attorney General to take over and continue any such criminal proceedings that may have been instituted by any other authority or person, and C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by him or any other authority or persons. But there are some controversies across various jurisdictions on the contemptuous definition of a juvenile or a child. The Child Rights Act 2003 defines a child as a person under the age of 18 years. However, Section 2 of the Children and Young Persons Act states that a child means a person under the age of 14 years. Article 1 of the Convention on the Rights of Children defines the holder of rights under the Child Convention as every human being below the age of 18 years. The 2 major sources of criminal law in Nigeria are the Criminal Code, which applies to the southern states, and the Penal Code, which applies in the northern states. Both laws make provision for juvenile as follows. Section 30 of the Criminal Code provides that a person under the ages of 7 is not criminally responsible for his act or omission unless it is proved that at the time of doing the act or making the omission, he had the capacity to know that they ought not to do the act or make the omission. Also, Section 50 of the Penal Code provides that no act is an offense which is done by a child under 7 years of age or by a child above 7 years of age, but under 12 years of age who has not attained sufficient maturity of understanding to judge the nature and consequence of such act. What these two sections imply is that in Nigeria, a child of 7 years and above can be prosecuted, but this must be done in a juvenile court. From the provisions of the Child Rights Act, juvenile cases are handled in family courts. Such courts are usually at the High Court level and magistrate level, and the magistrate and judge could be assisted by assessors. The assessors at the magistrate level must be officers above the rank of senior development officers, whereas at the High Court level, they must be above the rank of the chief social welfare officers. The officials handling juvenile cases must have the capability to do so, for such cases involve children. Officers like the judge, magistrates, and officers of the specialized police unit, supervisors, and child development officers. These basic rules governing juvenile trials must be adhered. Child trials cannot be held in public. Certain words are not permissible for use in courtroom, such as sex, imprisonment, sentence, conviction, and only the court can give authority before the child's identity can be made public. For now, it is unclear if the court will consider the Child Rights Act while determining this case, or it will focus on the Penal Code. Celestina Ira, TVC News, Abuja.
Well, outside Nigeria, the newly elected leader of the United Kingdom's Conservative Party, Kemi Badenoch, has promised to hold the Labour government to account. In her acceptance speech, Ms. Badenoch promised to win back voters for the Conservatives after winning the party's leadership contest. The 44-year-old succeeds Rishi Sunak and is the first black woman to lead a major political party in the United Kingdom. She defeated Robert Jenrick by 12,418 votes after a marathon contest. And here's what we know about the new Tory leader. Kemi Badenoch joined the Conservative Party in 2005 at the age of 25 and stood unsuccessfully for Parliament in 2010 and the London Assembly in 2012. She was also elected to the London Assembly in 2015 and to Parliament in 2017. She held a series of government posts in 2019 to 2022 in the government of Prime Minister Boris Johnson before becoming part of a mass ministerial exodus in July 2022 over ethics scandals that triggered Johnson's downfall. She ran unsuccessfully to succeed former Prime Minister Johnson, boosting her profile in the process. She was appointed the Trade Secretary in the 49-day government of Prime Minister Liz Truss and Business Secretary under Prime Minister Sunak. After the Conservatives' defeat in the 2024 general election, Badenoch was appointed Shadow Secretary of State for Housing, Communities and Local Government in Sunak's shadow cabinet. She later launched her bid to become leader of the Conservative Party in the 2024 leadership election. She also defeated Robert Jenrick